Yes.
May I please, Lord, should I
Hmm.
like to mention item number 40, my lord? My lord, Kondandi County is out of district, my lord. Sir, Amir Hussain. 40, my lord.
You're making this prayer on behalf of?
Amir Hussain.
On a prayer made on behalf of Mr. A. Hussain, learned counsel for the petitioner, who is stated to be out of station. Raised to list this matter again after 2 weeks on a date to be fixed by.
Obliged.
Yes, Mr. Bora.
Since I break with item number 41.
Oh,
I'm not pressing this case of you, Lord. Which revise it.
that absorption in seniority while absorption in. Okay. Mr. D.C. Bora, learned counsel, appearing for the petitioner. 14, submits that he is under instructions of the petitioner not to press this matter any further. Also, accordingly, the writ petition stands dismissed on being as not pressed.
Oh, obliged.
My lord, may I pray from a listing over date petition, my lord. It was last listed on 9th. Friday, my lord.
I'd like to mention for listing of the petition.
Please, Lordship. Item number 9, I would recommend.
Huh?
Item number 9. Perhaps my lord not to take up this matter, as my lord has appeared for the PDCL.
In
a
this
similar-
case,
Yeah, similar type of case,
similar type of case, what has it
That's
got to do with?
Sahayak selection.
You are
Related to
appearing for
Sahayak
whom?
Selection.
You are appearing for whom?
SP Sharma. Respondent.
9, list before any other bench without me.
May I please look in for? In respect to item number 18, my lord. I am appealing for the petitioner, my lord. Here I have received an instruction that today headmaster directed, there is a letter from the director asking the petitioner as well as the private respondent and headmaster to be present before the director of.
We'll say,
11:30.
we'll say, this last time you were not appearing, that's why we adjourned the matter.
My lord.
Let it come up today. We'll see. Yes, Mr. Deka.
45, my lord. I'm supposed to find the written note, my lord. I have got it, my lord.
Item number?
45, my lord. Supplementary list. Can we give it right now or let the matter be called, my lord?
Let it be called.
Lordship, in respect of item number 24 and 25, Lordship, I'll be receiving the instruction today. Lordship, may take it up after vacation, Lordship.
On the prayer of Mr. B. Chaudhary, learned standing counsel, BTC, who has submitted that the instructions in the matter would be received by him within the course of, within this week. Accordingly, he prays that the matter be taken up after 2 weeks. The above prayer is not objected to by Ms. M.S.A. Buzardova, learned counsel for the petitioner. Accordingly, registry to list this matter, please, 24-25, after the ensuing vacations.
Okay.
After vacation.
Yeah, for the petition.
Today's daily course list, top of the list, item 6.
Please, Lordship, may I kindly pass over the matter.
Item 7.
None has appeared for the petition on call. On the last date of listing also, it is said that none had appeared on behalf of the petitioners for call. This court had directed that the registry shall intimate the counsels about the listing of the matter. So accordingly, the registry had approached the learned counsels whose names are listed in the cause title for serving the copy of the order dated 23/11/2023. However, from the office note dated 11/6/2024, it is seen that neither the learned counsel nor the concerned advocate clerk had received the same. Accordingly, there being none to press the writ petition, the same stands dismissed for non-prosecution.
Item 8,
Yes,
but if today morning certain documents have been provided, but Lordship, I don't think these documents will help.
then you pay, then you will have to pay.
Lordship, 5 days, Lordship may fix the matter next week, Lordship. Just they seek further sometime.
If you can't produce that, your statement is not supported.
Fairly submitting, Lordship, they have forwarded some documents, but I don't think this
No,
will help.
Mr. Kolta, your clear statement in the in your writ petition is that this money was paid
Yes.
in his PF account. Fine. We say if you have paid that and he has received that, that is the end of the matter. But if you can't demonstrate that, how can we? Then we will have to direct you to pay that money.
Lordship, they fix the matter Monday, Lordship.
On the prayer of Mr. K. Kolita, who seeks further adjournment as a last chance to produce the information and documents as sought for by this court via the order dated 2/5/2024. To 5/2024 and 16/5/2024. So list this matter again on Monday.
Hello.
Item 10,
I'm corresponding 2, 3, and 4.
Madam, he had filed an appeal against that order of conviction.
That was rejected.
That was dismissed.
My lord, criminal case appeal, I do not know.
Who is appearing for the
That was
petitioner?
given to the, my lord.
Who is appearing for the petitioner? K.R. Bora,
sorry,
A.
Your
Chettiar.
Lordship, in this matter I am appearing
Okay.
for the petition.
Sachin,
Sachin, yes,
you are appearing for the petitioner?
yes.
Now, Mr.
Here, Your Lordship, two things have happened, basically.
No, first let me know what happened to the outcome of the appeal you filed against the conviction.
Yes. First, they said that the appeal, they've given an order, Your Lordship will
Uh-huh.
find,
Stay order.
no. The appeal, which appeal?
I am against that appeal that you have filed
Ah,
against the conviction of the trial court.
that has been stayed. Initially.
Then what happened?
That is annexed here.
Then what happened?
Then ultimately it went against us. We filed a
Dismissed.
revision before.
Hmm.
And in the revision petition,
It's pending for
it's pending, still pending. The revision is still pending before this one. Number one. Number two. First, what has happened? Here, they have, initially there was a departmental inquiry DP. I'll just give a gist.
There
of
was
the-
a departmental inquiry
That's
that
what I'm
culminated
just
in
saying that.
31/12/2013. That is the end of the matter.
That was on
Hmm.
certain complaints filed against it. That is the end, there was a punishment given fine. Now, the second part, again, there was a complaint petition filed before the court,
NIA.
NI. So NI, the punishment was given 6 months and an amount of 2 years. Fine. Thereafter, an appeal was filed. Against the appeal, there was a, that appeal which was filed before the authority. They said that the termination or dismissal cannot be withdrawn. On the ground that there was a, now the question arises, which is the most important part, which that is why I'm trying to point out, is whether in a conviction under 138 of the NI Act, there is moral turpitude or not. That is the question, because the punishment was on the basis
Show
of
me your
moral turpitude.
pleadings. Show me your
Yes.
pleadings to that effect.
Yes, there is. First, your lordship, kindly take up the decision, your lordship, order of dismissal for a moment. Page
I've seen it.
39.
I've seen it.
Yes,
You show me your statement. You are referring to paragraph page 17, second paragraph.
is
17, second paragraph. It's a long paragraph.
Yes.
There are 13.
constitute to be an offense and involving moral turpitude. Any case, the judgment order having been challenged or filed appeal, pending appeal, the operational judgment has been stayed. There has been no rational justification on the part of the respondents in applying the said judgment or relying upon the said judgment to purportedly dismiss the petitioner from the service. In the aforesaid petitioner humbly submit that the allegation of the respondent is contained in the implement letter of termination were more particularly to the effect that the petitioner violated the provisions of so of the TRA service rules only incorrect, misconceived, misplaced, and as the implement letter so and so the very way. So here, your lordship, basically the other provisions of 7.1, 7.2, 7.3.2. These three are provisions where you require a TP. 7.3.41 is moral turpitude conviction, where normally you don't
And
require a
Mr. Manar, on the day when they passed this order, rightly, wrongly, the conviction, that judgment was stayed, whether it can be stayed or not, that's a different issue altogether. That judgment was under order of stay. When the order was passed, if you
Fine.
can come to that order
Yes,
at page 37.
30. 37 was the order
Hmm.
of 13/11/2014. That is the order of stay of the criminal.
And the initial order of your termination was
Prior
on
to-
17/10
prior to
2000, prior to that, prior to that.
I'll come to that.
Hmm.
I have filed an appeal.
Hmm.
There is a provision of appeal.
But
under
they
the
did not
rules.
consider that.
I filed the appeal.
Hmm.
In the appeal, I have specifically stated that it has stayed.
Hmm.
Number one,
Now, when was this appeal of yours, criminal appeal of yours dismissed?
that was, your lordship, fine, at page.
No, that is a
54.
stay order is there. When was it dismissed finally?
Dismissed finally on, just a minute, your lordship, that was on the 8th December 2014. That is at page 48. This is where your lordship. Specifically, it was stated. I'm also coming to the order of conviction.
No. I'm not on that. Page 37, criminal
Page
case.
48.
No, page 37, there is a criminal case wherein there was a stay given.
Yes.
When did this finally culminate into a dismissal or rejection
appeal.
of the appeal? Criminal appeal.
Criminal appeal. Criminal appeal.
You will have it in your revision petition. You have filed a revision.
The revision petition has been filed. No, dismiss. They can't dismiss. No, dismiss. Then it is.
14/11/2014.
No, but it's for report. Dismissal order to 9. Filed there, na? With criminal case too. So revision petition from there. It to High Court of pending.
Okay. You mean to say that after that revision, after that dismissal of the appeal, you have also preferred a revision petition, then there is a interim direction there.
There is in this, before this on.
We'll have it
We'll-
after the vacations, you get me the status of that criminal. review.
We'll do one thing, your lordship. If possible, it's okay. We can bring it on record also.
By way of an additional affidavit.
Or we can provide the certificate.
Because
copy
that's
of-
the only ground in which you have been dismissed.
No,
Now,
why I'm trying to point out.
I got your point.
Yes, apart from that, your lordship, one thing is that the issue of moral turpitude, their judgment I'll. Moral turpitude in a case of 138 NI Act.
Whether
It
it will
is
be appealed.
not point. There are judgments. That's
They
what I'm
have-
trying.
they
If
have-
it is not moral turpitude, it
What-
is a civil nature.
The,
Then
the,
your lordship DP will have to be.
the sense that I get from the matter is, they wanted you out, you have become a very hot potato for them, and this was the easy way out.
That is.
This was the easy way out. Otherwise, the earlier proceeding done very nicely.
That was done.
Inquiry report is great. Brought in all required allegation, but
Yes.
the penalty was only reduction to one stage.
2 years.
AO2 to AO1,
One
something
for
like that.
2 years.
And that too also for 2 years only. So you were a hot potato there. They wanted you out. and this was the easy way out.
This was, your lordship, in 2 days. First, they have suspended within
And,
2 days.
and
the
that
order
too
was-
after the conviction. You were arrested after conviction and thereafter they put you,
Then
they
I
issued,
file- Normally, I file the statutory appeal before the authority.
they said that nothing doing.
That there,
Yes, madam, that conviction, at least when he had filed the appeal, was under stay.
at that,
How could you have not reviewed this order at that point of time? You get me that?
yes, it will.
When?
Lordship may fix it after.
Immediately
day
after
the
vacations. On the prayer of Ms. S. Mannan, learned counsel appearing for the petitioner, who submits that in the criminal appeal involved in the matter on being rejected, the petitioner herein had preferred a revision petition before this court, and the same is presently pending disposal. He submits that by the next date fixed, he shall bring on record the orders passed by this court in the said revision petition. So accordingly, registry to list this matter after the ensuing vacations on a date to be fixed by it. You bring it on record.
Much of
Madam, it's easy, but that is again fraught with problems. If he succeeds in the revision petition, that order goes.
Even the moral turpitude part also they have.
Actually, they have not-
specifically stated moral-
That we will handle.
Actually,
That we will handle.
they could have an inquiry proceeding, well, that.
You submit, we'll allow you. We'll allow you still. Take him back. Fine.
Much of.
My lord, in item number 9, my lord, my lord may not like to pick up the matter.
I've already said.
Item number 9. But it's the same matter, Bhoon Kumar Brahma.
It's enough. I have got enough justifications. Yes, who is appearing?
Item 11.
I'll update video.
12 and 13.
Who is there for the respondents? Mr. Soma, you are appearing for the respondents? Huh?
For the private response.
Okay. Now tell me one thing. Use it. There were 2 posts advertised. The petitioner claimed that there were 6 posts of LDA. You and the respondents have come down and said that there are only 3 posts of
Respondents probably in their affidavit.
affidavit have said that 3 posts are there. Now show me how reservation would be applied. Yes.
First of all, my lord, that contention. for
First, 1. 2, I want a government advocate, the senior government advocate here. Or anybody, government, get a government advocate. This conduct we will not support.
I'll come to that. The contention that there were only 3
Ah, Mr. Soikia is here. Yes, Mr. Soikia. Get hold of this file, 1076. You have it? You are a beneficiary of an order which was taken by suppression of facts before this court. Because in the earlier round of litigation, there was a stay order. That was not your fault. That was not pointed out by the government counsel appearing on that day. And the affidavit says by the authorities in this case that we had given all the materials. Now you support. You justify your case.
The contention of the official respondents hearing that there are only 3 posts in the cadre of LDA is not correct. It's an incorrect statement of fact.
We don't know.
From the records, from their affidavit itself also.
The other two posts they have shown to be ex-cadre posts. Morang,
More than one post.
one post.
One post. Out of the 5, one post they have shown to be ex-cadre. Now, my lord, if that was an ex-cadre post, Lordship is aware of, my lord, how come a person from a cadre post be promoted to an ex-cadre post?
So Sindas, that promotional vacancy.
Cylinder. How can, my lord, if it was,
We will not treat it as a direct recruitment post. For direct recruitment, we will limit it that there were only 3 posts.
the other
And
one,
you can't dispute the fact that for direct recruitment and for promotion, there will be different ACS.
my lord,
They're different rosters.
even assuming that to be an ex-cadre post, then also there are 4 posts, my lord. Because in the last sanction order, it would be reflected that they had sanctioned 2 posts of LDA in the establishment of director of archive. So there were 4 posts, my lord.
Okay, 4, we'll go by your saying, 4
4
posts.
posts. Now,
Okay,
2 was reserved for the reserved category candidate.
how?
Now, that law, my lord, I would like to rely on to
And Mr. Sharma, it's not reservation, it's backlog.
backlog, backlog.
Show me
Now,
how it is
judgment
backlog.
of the apex court, Katina of judgment. It says, Lordship is probably thinking of R.K. Sabharwal, my lord.
I'm not thinking of anything. I'm only thinking of
This
this.
judgment, after considering R.K. Sabharwal and a Katina of decisions, the Honorable Apex Court has held that even in a single cadre post, reservation would be applicable.
Which is that judgment?
Yes.
Which is that judgment?
Even in a single
Give the citation.
postgraduate Institute of Medical Education.
Therein it says for single cadre post, there can be no reservation.
It says, my lord.
Show me.
And there is another one, my lord, I'll place it. Following PGI's case, another judgment was rendered in the year 2009. In the case of, my lord, State of Karnataka versus K. Govindappa. And I'll refer to the relevant paragraphs. Paragraph 11 onwards, my lord.
Of this one,
Yes, yes. Even in a single cadre post, reservation can be applied by applying the policy of rotation. That is what has been said. Paragraph 11. May I read out the relevant paragraph? In the 11, 12, 13, 14, 13, then 16, 17, 18, 20.
Mr. Sharma,
Yes.
this judgment was placed before a constitution bench in 1998 4 SCC 1, and that was reversed.
In 2009 also, my lord.
We are not concerned. We are concerned with PGMIR. PGMIR, that's why I was taken aback. PGMIR judgment is you consult 1998 4 SCC 1.
My lord,
whether in a single cadre post, so and so, in a single cadre post, reservation at any point of time on account of rotation of so and so is bound to bring about a situation where such a single cadre post will be kept reserved exclusively for the backward classes and in total exclusion of so and so. Such total exclusion is so and so until there is plurality of post in a cadre. The question of reservation will not arise because any attempt of reservation by whatever means and even with a device of rotation of roster in a single cadre post is bound to create 100% reservation of such post whenever such reservation is to be implemented. So forget it.
My lord, not only that, my lord, following
So this gone,
this one, my lord,
Hmm.
same principle,
full bench is there.
2009 judgment, my lord,
This court is not going to accept that.
2009.
Forget it.
And in our case, my lord, it's not a single catapult.
You satisfy me how the backlog has come.
How the backlog is coming? Yes, that I can do.
Yes, Mr. Soikia.
In their affidavit, they have stated, now the copy of the affidavit has not been served upon me, so I'm a little bit handicapped. I've gone through the court records. They say that the first 3 appointments in the department against the post of LDA was made on the basis
So,
of
Mr.
merit.
Sharma,
Hello.
the first 3 posts, let's say there are 4 posts.
Okay,
4th post is vacant,
vacant.
which they have taken it for SC. The first 3 posts on the date of the advertisement were filled up. So where is that carry forward of the post? So that a backlog will come. So that 100% 16(4)(b) will not be applied.
They have in the state affidavit stated that
They have
these
not.
were-
They have not.
They have stated that these were carried forward.
No, how can they be carried forward when the posts are filled up? They have given a list of dates when the persons have retired. The first person, he will retired in 2016. The second one retired in 2012, May. And this advertisement was of July. How can there be a carry forward?
Well, I don't have a copy of the affidavit. That was not served upon me.
We are not satisfied in the manner in which this thing has been done. This court's order was suppressed before this. Yes, Mr. Soikia, what steps have you taken? Come to your affidavit. Come to para 11. Para 11. So and so did not inform the honorable court about the pendency of the writ petition and interim order dated so and so. Necessary parawise instruction clearly indicating the fact about the pendency of the so and so and interim order operating therein were sent to the concerned government advocate for filing affidavit before so and no. Now, if you come to the statement of the government advocate before this court in the proceedings held, that you will find at page 32 of the writ petition. Para 14. See, because of your inaction, this court was required to pass directions towards appointing them, wherein in an earlier proceeding, the appointment was stayed. Right? Now you refer to certain communications issued. Para 11, that is at internal page 20 onwards or running page 58. Now, tomorrow, I want these communications in original along with the endorsement of receipt by the government official. Otherwise, even if they are not in service, I'm going to haul them up here. Tomorrow. Mr. Halloy, let it come tomorrow. And Mr. Sharma, reframe your arguments. This we are not, and you want that reply? It's here. In the other writ petition, 6148, there is an affidavit wherein this has been clearly done, but you will get it here also, internal page 3 of the affidavit.
That's copy
They-
of the picture.
I don't know how, what can I do? Third post that is there, that is vacant. You come to page 3, it's a part of paragraph 7. And we will not go beyond this. And you see here, the post, one of the posts that was advertised was filled up by Sokorodor Deka, who retired on 31/5/2012. Where is the question of carrying over forward the post? The point may have carried over. So how can you have two posts, 100% reservation in violation of 16(4)(b)?
In fact, 4 posts were filled up in that.
We will not go beyond this. We will not go beyond this.
There were 4 posts.
They say Sokorodor post was advertised and another vacant post.
My affidavit, I've given the advertisement.
Four.
Four posts.
2 posts.
Yes, there was a subsequent advertisement.
We are not concerned with that. That is not before us.
Immediately thereafter.
That is not
Within
before
3
us.
months.
We are not concerned with that, Mr. Sharma. We can't be concerned with that. We'll only be concerned with this. And in the second affidavit, they have given in clear terms in para 5. Deponent states that as per the gradation list of employees as on 1/5/2012. So backlog will require the post along with the point to be transferred, carried forward, 16(4)(b). Manik Chandra Rajbangshi will retire in 16. Sokrodor Deka retired on 31/5 and the third post vacant. So 50% if you have to, you can cross 50% reservation in a particular year if the post is carried forward and added to that. Then that will not be taken to consider 50%, 16(4)(b). Now, how can you go beyond this? You will have to interfere with this. You get me your things tomorrow. Mr. Soikya, get hold of this. I want it tomorrow. Mr. Hollow, we'll see it tomorrow.
Item 15.
Update with you.
In this case.
Have you received the balance amount?
No, my lord, I'm not concerned. I am regarding the my lord content account.
Ah, that's it. Have you received the balance?
No, nothing was received. Single file.
No, they say that a part of it was, the order reflects that 1,53,000 was, and a portion of thereof was sanctioned to you. Yes, Mr. Sharma.
Yes, ma'am.
Sanctioned full money?
Yes, ma'am.
Show me.
Already being drawn and disbursed.
Show me.
Yes.
There is also interest is there. Interest.
That.
My court has passed order, madam. And post has been imposed, madam. Court has passed order for interest as well as for past.
Heard Mr. K. Maheshwari, learned, A.K. Maheshwari, learned counsel for the petitioner, also heard Mr. U. Sharma,
My lord, I am appearing on behalf of A. Fukon, my lord.
appearing on behalf of A. Fukan for the respondents. The respondents have placed before this court a communication dated 15/6/2024, by which it has been highlighted that the amount as sanctioned being the area salary of the petitioner amounting to rupees 1,53,387 has already been drawn and disbursed to the petitioner, and she has received the same. Full stop. Mr. A.K. Maheshwari, however, referring to the order dated 7/12/2016, has submitted that the respondent authorities not having released the area salary in terms of the directions passed by this court within a period of 2 months thereof, this court had directed that the amount so receivable by the petitioner shall carry an interest of 6% per annum, which would be borne by the commissioner and secretary of the department. Also, in view of the material brought on record, in view of the particulars placed before this court, to the extent that the area salaries of the petitioner has been released, this court finds that there is substantial compliance of the directions passed by this court, and accordingly holds that there is no willful and or deliberate violation of the directions passed by this court in the matter. However, with regard to the issue of the petitioner being entitled to receive 6% interest on the amount due, in terms of the directions passed by this court by order dated 7/12/2016, this court permits the petitioner to approach the respondent authorities by way of a representation, praying for release of the same. Full stop.
Already retired from service.
Make an application. There is substantial compliance, Mr. Maheshwari. And we were satisfied long back. The substantial compliance is there. Willful deliberate violation is not there.
Will it take him?
That's why we are giving you an opportunity. Please avail that opportunity. Because contempt would come in when there is clear and deliberate violation. That I cannot draw into it, read into it. क्या लिखा है? A respondent by way of filing a representation, praying for release of the praying for authorizing to her the amounts due on application of 6% interest as directed by this court on the areas as a receivable by her in the matter. Also, in the event of such a representation being filed, the respondent shall consider the same and release to the petitioner the amounts due to her on account of the application of interest as noticed above within a period of 2 months from the date of receipt of such representation. With the above observations, the contempt petition stands closed. A copy of the communication dated 15/6/2024 as produced by Mr. U. Sharma is kept on record and marked as X for the purpose of identification.
Supplementary course, please. Top of the list, item 45.
Small notes. Heard Mr. S. Kotoki, learned counsel for the petitioner, and also Mr. N. Deka, learned standing counsel IOC, appearing for the respondents. Also heard the parties at length. The parties have also placed on record their respective written arguments, which is have also furnished their respective written arguments, which is also taken on record. Also, the accordingly, the hearing having been concluded, case judgment stands reserved. Also heard Mr. K.M. Halu, learned counsel, appearing for the private interest. You are continuing.
46.
Yes, madam.
Have been your lordship. Petitioner got promoted on 25/1/1995 to the post of inspector. Thereafter, lordship on 23/12/2002.
You give me the dates.
Yes, lordship.
Dates. Give me the dates again.
25/1/1995, promotion to the post of inspector, lordship. Thereafter, lordship, on 23/12/2002, lordship, officiated to the post of development officer. That is my annexure, lordship.
Okay. Then,
Annexure to lordship.
then,
Thereafter, while I was officiating in the post of development officer on 6/8/2004, lordship, again officiated to the post of district officer. That is, lordship, annexure 3, page 13, lordship.
what is your grievance here?
But I was drawing my salary as an inspector and I retired and I was superannuated
When?
on 31/12/2013 as an inspector. Although I was officiating at that time as district officer in both district, lordship. District,
Okay.
I'm
What is the
officiating,
methodology of promotion? Hierarchy, inspector, development officer, then district officer.
yes, lordship.
What is the criteria? How is it promotion effective?
So-
What is the rules holding the field? Means what is the method of this promotion? There will be something somewhere.
Mostly, my learned friend will say, but in this case, Assam rules, service rules applies.
There is no post of development officer and district officer in those two rules.
Then I need to do more research. work
Because
on
here
that.
there is nothing.
Yes, I need to do more research work on
That's
that.
why I think last time I asked you,
Yes,
you are asking for two promotions at one go. How? Yes, Munir. How do you justify this action? 2002 to 2013, keeping a person on officiating basis. What was the purpose? What is her seniority as an inspector? How many posts of development officer? How many posts of district officer do you have? Where are those particulars?
I'll have to get the instruction now. But if my lord comes to page 12. Page 12, they are directed, the second line, second paragraph, at present, they will draw the present scale of.
No issue on that. No
in
issue
the-
on that. No issue on that. If it is a officiating promotion, naturally she will draw the. But my question is now to reject her case. You want me to reject her case, right? Or you want to allow it?
No, my lord,
No. You want me to allow her case or reject her case?
I am just helping your honor, my lord. But, my lord, they approached this honorable court, my lord, and the honorable court, my lord, directed that we file a representation and
What happened to that?
yes. That order,
At page 16.
yes.
Then
Thereafter, she was promoted, my lord, given the promotion, my lord, with effect from, my lord, later date, my lord, at page 18. With effect from,
now you tell me. No,
17,
that's what I want to
2018.
understand.
now she is claiming from the date of 2002.
That you
That is
forget
the
it.
position, my lord.
Now there is an intermediate post called development officer. What is your hierarchy?
That I will bring, my lord.
Inspector to development officer or inspector direct to district officer?
It will be often for it, my lord.
That is the basic intention.
And the
Otherwise, we will say that this promotion given is fine. Let her enjoy her retired life. But if we find that there is another promotional post
Right.
in between,
two.
then she has to be promoted to that, given the benefit therein, and thereafter the fixation made as district officer, she'll gain something more for her pensionary benefits.
I could follow your logic. I'll bring this.
Day after. Thursday,
Can it be on Friday, man?
Thursday.
Thursday?
Thursday, you have any inconvenience?
No,
Right.
Thursday also.
Friday. As agreed to by the parties, list this matter again, as prayed for by the parties, list this matter again on Friday. On the next day of listing, the parties shall place before this court the rules and or service orders in place pertaining to the manner, pertaining to the manner, pertaining to the procedure required to be followed for recruitment to the post of development officer and district officer in the respondent organization. Full stop. The parties shall also place on record the seniority position of the petitioner in the cadre of inspector, as well as the minutes as reflected as well as the recommendations of the Departmental Promotion Committee as noted in the office order dated 10/3/2014, by which the petitioner herein was promoted to the post of district officer with effect from 17/7/2013. Get that? Either you or he, whoever. Otherwise, we don't have anything to judge, adjudicate the matter. Merely officiating will not give you a right. That is officiating only.
Much of.
But yeah,
Timing 11.
This matter is in flux.
that's why I did not dismiss it for default. Mr. B.N. Gogoi, Learned Counsel, appearing for the petitioner, has submitted that during the pendency of the present proceedings, the petitioners have been given their entitled rights, entitlements. And accordingly, he submits that no further live issue arises for consideration in the matter. So accordingly, in view of the submissions made by Mr. B.N. Gogoi, Learned Counsel for the petitioner, the writ petition stands dismissed as having become infructuous.
Motion item 17 and 18.
So Barbara lies in another court. In fact, he also admits that today there is a hearing. All the parties are called before the.
We'll close the matter then. Mr. Goswami, if that is the contention,
Next week, Malad.
if there is a procedure done, disputed questions, let them take whatever decision happens. Because you have subjected yourself to that process. Subjected. Why two parallel process?
No,
And when the matter is pending before this court, how can they have this exercise?
Next week, Malad.
No, today. Last time we heard it, Mr. Goswami, you did not appear. That is the only reason why we adjourned the matter. We are not adjourning it. You get it. You get him.
And Mr. Barbara also admits that all of
We'll
them
close the matter.
Malad,
We'll say
he
that
lies in
whatever
another
hearing
court.
takes
That is
place,
why-
pass speaking order that will hold the field. We'll provide for that.
Can it be next week, Malad? My humble prayer.
Malad, as per my.
As prayed for by Mr. UK Goswami in WPC number 6324/2023 and reportedly as prayed for by Mr. UK Goswami, Learned Counsel for the petitioner in WPC number 6324/2023 and not objected to by, yes, Mr. Sharma, you have something to say?
Yes, my lord. Today's hearing is going on, my lord. So, my lord.
If that hearing is going on, how can they come to a conclusion when this writ petition is pending here? Or you have that power to come to what is the intention of that? Have you taken a leap from this court? Then? As per your wishes, you proceed. We will also say, we'll close the matter. Now that they have subjected to that process, get Mr. Barbuya. We'll see. We get Mr. Barbuya. Mr. Goswami, get Mr. Barbuya. We will see.
He requested that he lets him put down one.
Wherever he is, he'll not be there for the whole day. I'm sitting here for the whole day. Get it? Because last time we heard this matter at length. Only because you were not there. We did
Last
not.
time, only 10 minutes late, I came before the court, but I already, matter was over, madam.
After that, ask him to come. After that, ask him to come.
I requested to make a play before to take it after some time.
After some time. Fine. After some time.
Or can it be at 2, madam?
I don't know whether I'll be here at 2. I'm not in a position. Okay, 2.
Highly obliged.
19.
Yes.
It relates to arrears salary as well as the pension benefit salary.
Who is appearing? Yes, madam. What is your instruction?
Instruction received, your lordship.
Yes.
Where your lordship, it has stated that that Srimati Panita Hajurika did not join her post in the Bhole Bagan Higher Secondary School due to certain circumstances, and that there is no record of her service in the said institution. I would like to place it, your lordship.
When did you retire?
Retirement, 39 2023.
And for this period from July, no, July 2010.
To 3/7/2010.
After that, where did you function, work?
After that, she get all the after.
Huh?
After that, madam, she was retired. She was transferred from
Dolegaon?
School to Mongolda High School.
Mongolda High School. Where is that order?
Mongolda High School.
Where is that order?
Madam, transfer on 24/6/2010.
That is page 30. And thereafter, the salaries were being paid. Yes, madam. It is not her fault that she could not join. Why is her salary is not being released? You admit to that she was prevented by the public and the headmaster. Why was steps not taken in the matter for immediate transfer?
I may allow to obtain up-to-date instruction.
What more instruction will you obtain? You have already obtained. June to 28/8/2009, you have been paid. Now only from 21/8/2009 to 3-7. Come to page 31, madam. Mr. Buragoy, you have your seat.
Hello.
You can have your seat. So this shows that she was there. If she was there, how can you deny her salary? Because she has not. You say that she had joined. She was not allowed to sign the signs attendance register by the school authority under public pressure. You have not taken any steps. So when are you releasing this amount to her?
Actually, referring to this letter, your lordship, I may allow to obtain instruction.
Initially, she was appointed, Dolbaga, Mothapur High School.
Got her put, then he was transferred.
Dolbaga.
So the Ms. P. Das learned heard Mr. B. Burang, learned counsel appearing for the petition, and Ms. P. Das learned senior learned standing counsel, secondary education department. Ms. P. Das has placed before this court a communication received by her from the district elementary education officer, inspector of schools, from the inspector of schools, Soraido district circle, Soraido, wherein it has been highlighted that the petitioner was not allowed to join her post, join her post in Dole Bagan HS school on transfer due to certain circumstances, and there is no record of her service in the said institution. So, the prayer in the present petition being for release of her salaries for the period she had served in Dole Bagan HS school, that is from 21/8/2009 to 3/7/2010. The claim in the present proceeding is for release of the petitioner's salary for the period of her service in Dolebgaon HS school from so-and-so to so-and-so. The materials brought on record in the petition reveals that the petitioner had submitted her joining report in Dolebagan Higher Secondary School. However, she was not permitted to sign the attendance register by the school authorities under pressure from the public. Also, however, noticing the said position, although belatedly, the respondent authorities had wide and order dated 24/6/2010 transferred the petitioner from Dolebagan HS School to Mongoldoy Town Girls High School. Also, in pursuance to the said order of transfer, the principal of Dolebagan HS School had released the petitioner from the said school on 3/7/2010 and therein had certified that the petitioner had submitted her joining report However, the records of the same is not available inasmuch and further that the petitioner was not allowed to sign in the attendance register maintained by the school authority under pressure from the public. However, the principal of the said school proceeded to release the petitioner from Dolebagan Higher Secondary School in the afternoon of 3/7/2010, which indicates that the petitioner, although was available for discharging her duties in the said school, however, for discharging her duties in the said school, but she was prevented from doing so by the school authorities for reasons other than lawful. Full stop. In view of the above, the Inspector of Schools, Soraido District Circle, is now required to, in view of the above, the Director of Secondary Education Assam is now required to take a decision in the matter pertaining to the manner in which the period of service of the petitioner in Dolebaga Higher Secondary School is to be regularized. Also, Mr. Buragohe has further submitted that the petitioner has since retired from her services and her pension papers are not being processed on account of the fact that the period of her service rendered in Dolebagan HS School is not regularized. Also, on the next date of resting, the Director of Secondary Education Assam shall place before this court the manner in which the services of the petitioner in the said school has now been would now be regularized. Also, further, the Director of Secondary Education Assam shall examine as to whether the petitioner herein is entitled for being paid her pension and pension benefits under the old pension scheme, and if it is found that the petitioner is so entitled, a provisional pension shall forthwith be authorized to the petitioner pending finalization of her pension and pensionary benefits. The communication as placed on record by communication as furnished by Ms. P. Das, Learned Standing Council, Secondary Education Department, is kept on record and marked as X. Let's see. If she is entitled to a pension and pension benefits, release to her a provisional pension. Then do whatever you want to do. When we are paying for?
I'm looking for respondent number on behalf of respondent.
Respondent number?
4.
Miss
S. Barik.
S. Barik.
Barik.
Learned Council appears for the respondent number 4, and Mr. R. Borpujari, Learned Standing Council, Finance Department, appears for the respondent number 3. 3 and 5. List list after 4 weeks. On a date to be fixed by the list.
Item 20.
Kivan? Yes, Mr. Motor.
Provincialization of the petitioner has been held up because there was some doubt with regard to her MA degree, which she had obtained from CMJ College. Situated such manner, she had approached his honorable court.
Obtained from?
CMJ College.
Oh.
And thereafter, she approached the Honorable High Court, and Honorable High Court passed a judgment on 15/7/21, whereby it was directed that you take the process to a logical end and you issue a speaking order, Thereafter, we made representations, and there were certain subsequent developments. If my lord comes to page 49 and 50, the authorities clarified the stand from the university, page 49 for a moment, kindly.
Was this a degree?
Yes,
while she was working in that venture school?
Yes. So, my lord, page 49, the university has clarified. It has been.
When was this degree procured by her? When was that course of study undergone?
Procured in the year 2011.
Course of study undergone?
2011. 2011, my lord. The mark sheet is also there, my lord.
1 year.
Page number 17, my lord. The MA certificate, pass certificate.
Only 1 year course of study.
So, the
2011.
page 49 and 50 would clarify, my lord.
Where is your degree? Degree from?
Mark sheet, my lord, page 17.
No. This is MA.
MA. So the MA is doubted, my lord. MA was.
What is the school? It's a secondary school.
It's a college, my lord.
College. And you were appointed initially as?
Initially as a teacher in the year 2000, my lord, and thereafter promoted to the post of principal on 5/10/2015.
Without an MA degree?
I had a MA degree, my lord. MA degree was obtained in the year 2011. Now.
When did you join the school?
2000,
College, sorry.
25/07/2000.
2000.
Yes.
From 2000 to 2011, you did not have a qualification.
No, my lord. MA. I
And
did not
thereafter,
possess
you
any.
went and had this one. Okay, where is that speaking order?
My lord, speaking order, no, my lord, there's no speaking order. That's why we have approached this court. There's a judgment, my lord, page 26.
In pursuance of that, they have not issued any order.
Not issued any order. They had clarified thereafter. My lord. They had clarified with the university, which my lord would find at page 49 and 50. Which the university says, I'll read it out, my lord, page 49. This is addressed to the Additional Secretary, Government of Assam, Secondary Education Department. Sir, with reference to the subject cited above.
Okay, I got it. And what is this 51?
Page 49.
51?
50 again, there's a clarification.
51.
51, my lord, it's a list, my lord, that my provincialization held up, my lord. There's again, they have, in the year 2022, that process has been started again. And they have already clarified, my lord. This university has also clarified that it's, my lord, may produce the last order.
I think there are some proceedings pending before the division bench in this connection with regard to the validity of the degrees procured by.
CMJ, my lord.
Huh?
I have to find out.
Oh, expert is behind you. There were some proceedings before me. Yes, Mr.
My lord, that is regarding BEd degree.
BEd degree.
My lordship has been.
And I think you pointed out some other cases pending before the division bench on that day, if I remember correctly.
No, another series is pending before another single judge, the court number 2.
That is heard.
Heard and CAV.
Save is that issue. What is the issue there?
Not MA, my lord, that is also BEd.
BEd.
I think MA is the first time my learned.
MA is first time. And Mr. Monta is the pioneer now.
Well, if my lord kindly produces 50 for a moment, my lord, page 50.
Just a moment,
My
just
lord,
a
my lord.
moment. Just a moment.
Services of the other employees have been provincialized, except.
Yes, madam, what is your stand?
Your lordship, I would like to file our affidavit, your lordship.
Fine. You file your affidavit. Who is barring? What is your instructions?
Your lordship, I would like to place it, your lordship.
Page 50, my lord, would find a notification by the university, the second last paragraph of my lord kindly produces. It's a constitutional entity, page 50, and the university is a creature of this committee.
This is a junior college,
Junior college,
senior secondary,
junior college, sorry,
junior college.
junior girls college.
Last 3 columns, your lordship.
Heard Mr. P. Monto, learned counsel for the petition, and also Ms. P. Das, learned standing counsels, secondary education department. Also, the materials available on record reveals that the petitioner herein had earlier approached this court by way of instituting WPC number 3260 of 2021. And this court, by an order dated 15/7/2021, had disposed of the said petition by directing the Commissioner and Secretary, Government of Assam, Education Department, to examine the to pass a reasoned order on the acceptability of the MA degree as acquired by the petitioner and pass a speaking order thereon. Full stop. It is the contention of the petitioner hearing that the said order has not been passed And although there were clarifications received from the university wherein the petitioner had pursued her MA course, the government had not taken a call in terms of the directions passed by this court in the earlier round of litigation with regard to the MA degree of the petitioner, and accordingly, her case for provincialization under the provisions of the Act of 2017 Pura Likhiniva has not been considered till date, causing prejudice to her service interest. Full stop. On the next date of listing, Ms. P. Das shall place before this court the order as required to be passed by this court, wide order dated 17 shall place before this court the speaking order as required to be passed in the matter, wide order dated 15/7/2021 in WPC number 3260/2021. Full stop. The said order would be so passed strictly in accordance with the directions so contained in the said order. So further orders as would be called in the matter would be so passed after the said order now required to be passed in the matter with regard to the acceptability of the degree of the petitioner is brought on record. This matter again after 4 weeks on a date to be fixed by the registrar.
Only a date, I'll get a date fixed.
By pass an order. Only requirement is pass an order. Why should I again come in? Pass an order. If you find this degree, fine, go ahead. If not, bring on record material.
In that.
That, don't let me go into that.
Yes, Your Lordship. I'll find
This
it.
is 2017 Act. That will not come in, madam. 2017 Act is on the date when you are examining whether he has qualification, he'll be a teacher. If he does not have, he'll be a tutor. You cannot go beyond that. 310 and onwards, see. So kindly impress upon your authorities that this order of this court, earlier order of this court, has to be complied with. Right? Pass an order. If you find that she is entitled, give her. If not, reject it.
Yes.
Give reasons. Bring it to us. We will examine. Finished.
Supplementary course list, motion item 47.
Yes, Mr. Bhuyan.
Fine. May I please your lordship?
Hmm.
Lord, the matter is, Lord, regarding promotion of the petitioner as headmaster under Rule 14 of the 2018 Secondary Rules Committee. Lord, what has happened? All the petitioners were clubbed together, my lord, were they initially appointed as a graduate teachers in their upper primary schools. Lord, I have given the details in paragraph 2 onwards, my lord, of the petition. Along with I have also annexed the, Lord, the initial appointment and present status. Now, my lord, as a policy of
You were appointed initially in a ME school. Thereafter, that got amalgamated with a high school.
high school.
Hmm.
Now, my lord, Rule 28, my lordship is well aware, my lord. Rule 28 says now they will be treated at the cadre of, my lord, these secondary level schools.
Hmm.
Strength, my lord.
Hmm.
Now, my lord, what has happened? The process of selection for the purpose of promotion of the headmaster has been initiated, my lord. Initially, my lord, a notification has been circulated
Hmm.
in the year 26/9.
What is the prejudice now caused to you?
My lord, prejudice caused to me, my lord, the department, but basically the inspector of schools are not, my lord, intending to accept our annual confidential report, my lord, saying that, my lord, our service tenure, my lord, as a graduate teacher can only be counted from the date of amalgamation. The original, that is not the purpose of the rule, my lord. As my lord.
So your prayer here is,
My lord, we may be allowed to participate in the recruitment process, my lord. That is the limited prayer. The process is already going on, my lord. Even in the gradation list, my lord, our name had also been included. Thereafter, the difficulty arises.
also, Lekha, heard Mr. A.R. Bia, learned counsel for the petitioner. Also heard Mr. U. Sharma, learned counsel, standing counsel, secondary education department, appearing for the.
Well, in this matter, some petitioner is
belonging to Morigaon district and some Nagaon district
No.
of the government.
We have categorically stated.
So, the petitioners in the present proceeding have contended that they were, although they were initially appointed in ME schools, upper primary schools.
primary.
However, on their such schools being amalgamated with high schools, comma, the petitioners herein became members of such high schools and were governed by the secondary education department with effect from the date of amalgamation of their said schools. The petitioners contend that they have the requisite qualifications for being considered for the post of headmaster. However, in spite of submission of their respective applications and also incorporation of their names in the amalgamated, in the district-wise gradation list for consideration of such promotion, both in Morigaon district as well as in Nagaon district, comma, the petitioner's cases, the cases of the petitioner are not being considered in as much as it is the view of the inspector of respective, it's a view of the jurisdictional inspector of schools that the service tenure of the petitioner for the purpose of reckoning as to whether they have the eligibility for being considered for the against the post of headmaster would be so reckoned only from the date of their entering into the secondary school upon amalgamation of these services. Also, Mr. Bria submits that the same is in clear violation of the provisions of the Act of 2018. Yeah, some secondary education, provincialized service. 18. Also, Mr. U. Sharma shall receive instruction with regard to the contention as noticed above of the petitioners in the matter and place the same before this court on the next date of listing. Accordingly, list this matter again on today's 18, 24. So, further orders as would be required to be passed in the matter would be so passed basing on the instructions placed on record by Mr. U. Sharma on the next day.
Madam, extra copies may be charged to us.
I'll supply.
If they don't supply, don't bring instructions. You come and tell me. I'll give you another 2 weeks' time, their work will be done. Get my point? You come and tell me next day that copies have not been served.
Yes.
I'll adjourn the matter for 2 weeks. After vacations, when this election is over, we'll see what can be done.
I will have to face of life. Today itself,
And with signature.
Eventual losses, we were joint or any other loss. I today.
I'll be also happy. Today I'm also not. 2-3 days I've been having this viral thing.
One convenient that may be given by this.
When? After vacations?
After vacation,
Before vacations would be difficult, mister.
why not then after vacation?
Immediate.
Why not?
As prayed for by the Learned Council for the parties, raised it to list this matter again on DD.
We commencing from 22.
Me a date.
No, my lord, 22 I will be out of session.
I know. Give me a date, mister.
That will
Any
be
date convenient to you.
24 or 25th, my lord.
24,
25th, my lord, that will be better. 25th.
25,
No, sir.
25, 7 day.
In this two petitions, my lord, I mean led by Mr. K.N. Choduri, my lord. My lord, presently he is before the special bench, my lord. At court.
Oh.
So this matter will take some time, my lord. So may I pray that this matter may become for another day, my lord. Is not
Subject to
convenient to you.
Mr. Das is there. What do you say, Mr. Das?
My lord, we want to do the matter, my lord. If he don't like, my lord, maybe after some time.
He said to be on a special bench today.
Yes, my lord. This matter will take
That
some
may
time.
take some time. That teachers matters.
These are the Provincialization Act matter.
Thursday?
This week
Or
would
it
be
has to go after
slightly,
vacation.
I'll have it, if you want, I can have it on 25th.
Immediately after vacation, my lord, the 25th. I have some indication. Immediately after vacation. my
We'll have it immediately on vacation. As prayed for by the item number 2223, as prayed for by the Learned Council for the parties, list this matter again on 18/7/2020. 18 is a Thursday
Thursday,
for admission hearing.
deeply obliged.
As prayed for by the petitioner.
As prayed for
Yes,
by the
yes,
petitioner and not objected to by the respondents.
I'm deeply obliged.
Record should be stated.
Huh?
Record should be stated.
Or seniors like Mr. Das is always there to guide me to that.
26. My lord, right earlier order, my lord, we need to file affidavit in opposition, my lord. We have already prepared and sent the same for signature, my lord. So sometime may be granted.
Your contention on the last occasion was the medical bill that he has claimed was already reimbursed to him, right?
Yes. 3 lakhs of payment has been made to the petitioner, my lord.
No, where is that, Mr. Counsel, where is that referral letter and the amount?
Annexure 17 page 158. Original bill of rupees around 7 lakh rupees.
I'm not on the original bill.
Original
This
bill
bill might have been scrutinized by the director.
It's about option.
Page 1.
158. Lord. After going for the bill, they have accepted also. Handwritten copy lordship page 159.
100?
Handwritten page 159. Submission of original medical bills.
Where is that finding that this is amount has been accepted by the, So they have only accepted 3 lakhs.
They have given 3 lakhs, sanctioned 3 lakhs.
Okay. Now, where is that fact? Where is a document to show that this page 158, your claim 7,04,000, that they have accepted that 7,04,000? Is there any document?
Also, after going for the bill, after second.
My lord, kindly-
Accepted this representation.
Kindly see our medical board medical attendance regulation of 2016, my lord. That has been amended, my lord, in the year 2019 with effect from 1/1/2019. Kindly see, my lord, at page 3, my lord.
3 lakhs. What
Clause
was the
9.
ailment? What was your ailment?
Heart ailment lordship, CABG surgery was conducted.
See?
Coronary artery bypass
Surgery. was-
surgery. And perhaps lordship kindly have a look at page 119 lordship, full reimbursement regarding bypass surgeries granted lordship in terms of SEBA health regulation. SEBA authority cannot set up for an appeal upon the order passed by this honorable court lordship after all.
Just a moment, just a moment, just a moment, just a moment. So under this regulations, you mean to say full reimbursement, so and so, so and so. What is the direction of this court in the last round of litigation?
Kindly have a look at the page 154 also. Direction part.
My lord, direction at page 154 of the writ petition, my lord, at paragraph 25.
Yes.
Yes. My
So,
lord, here, my lord, directed that the board will re-examine the matter and after due verification of the claims made by the petitioner for medical reimbursement of
now
expenses.
show me
Yes, madam.
that you have examined the case strictly in accordance with
Yes, my
page
lord.
140, 54 and
Yes,
155.
my lord. My lord, kindly see, my lord, this, my lord, our board medical attendance regulation 2000.
I'm least bothered with that.
Yes, ma'am.
I'm bothered with my order.
Yes.
25.
Yes.
25 required, this board regulation was there when 25 was passed. Directions, it was there.
Yes,
How have you dealt with it?
my lord, as per our, my lord, this board regulation, my lord, there is a maximum reimbursement.
No, there is a further given that ex post facto approval, relaxation
Yes,
is to be considered in respect of the petitioner's
Yes.
husband's surgery.
Yes.
How have you considered it?
my lord,
This was there when this order was passed.
yes, ma'am.
It was in the light of this that this order was passed. So how have you considered?
My lord, hereafter, my lord, the board.
Now, if you are referring to this, what is the use of this direction?
My lord,
Some meaning has to be given to this
my lord,
direction.
hereafter, my lord, we need to file our affidavit, my lord. We have sent the.
But I want that how this matter was discussed.
Yes.
If you only say it's 3 lakhs, this time we are issuing mandamus.
Let us file our affidavit.
Let him bring it on record. But I want that. Oh, this is your agenda item number 10.
Yes, my lord.
Huh? There is no discussion. You only refer to this, you don't refer to the High Court order. How can you? What is then this beauty of passing such directions by this court?
Yes, my lord,
Then somebody has a grievance, he came up before this court. This court directed you to consider the matter in a particular manner. This could have said, do it in terms of your medical attendance rule. That was the end of the matter. This court did not do that.
Yes.
It said go beyond that because he had a heart ailment, which was fully reimbursed.
My lord.
And there is a relaxation also here.
Yes.
Huh? This court directed for a relaxation in the matter. When the board is satisfied, so and so, dispose, relax, so and so. Where is your relaxation considered? This resolution does not show consideration of any relaxation. Come to board agenda item number 11.
The agenda number 10, my lord.
10 is per petitioners,
Yes, ma'am.
right? Now come to 11.
To discuss the matter of reimbursement of medical bills submitted.
Come
by-
to the second part. Agenda item number 11, right?
Yes, my lord.
Come to the second part.
My lord, honorable members of the board discussed the matter and decided to release the amount as per medical attendance rule amended in 2000, which is maximum of 7 lakhs in case of cancer treatment, my lord, for the ex-employees and dependents. As such, permissible amount to be released in 7 lakhs minus rupees 44,174, total 6 lakhs 55,826, my lord, only.
So because of cancer, you have given him the full amount. That's
Yes.
the reason. Okay. Now, but here, this court had required you to act in a particular manner, right? And also to invoke clause 17.
Yes, ma'am.
Why was that not invoked? Or even considered to be invoked? You take a call.
Yes, ma'am.
If required, redo it and then file an affidavit. Mr. D.K. Roy, learned counsel for the petitioner, heard Mr. G.R.A. M.U.T.T.A.Q.U.E.E. And also heard Mr. D.K. Roy, learned counsel for the secondary board of secondary division Assam. So Mr. D.K. Roy submits that an amount of rupees 3 lakhs has already been released to the petitioner and he would like to file an affidavit in the matter justifying the release of the said amount. Also, a perusal of the directions passed by this court while the order dated 22/6/2022 in WPC number 1481/2022, while reveals that while remanding the matter back to the board authorities for a reconsideration thereon, and a liberty being given to the respondent board to take recourse to the provisions of clause 17, relaxation provisions of clause 17 of the Medical Board Attendant Regulation 2016 as amended in the year 2019, the resolution as adopted by the board in respect of the petitioner does not reveal that the directions as passed by this court while the said order was so considered while determining the quantum of medical reimbursement bill required to be sanctioned to the petitioner. Full stop. Mr. Roy shall in his affidavit also clarify the above position. However, further liberty is granted to the board authorities to have a relook into the matter and pass fresh orders as may be called for after considering the directions passed by this court in the matter. Also, raised to list this matter after 6 weeks on a date to be fixed.
Yes,
by.
ma'am.
Let them do it. If they do it, fine. Otherwise, you come back to us.
Much obliged, my lord.
Please, admission 1948.
Here, this is your lordship. Last occasion, your lordship, verification, your lordship, the documents verification. Maybe that your lordship already, communication letter has already been sent.
You have not got it back.
So.
Okay, we'll give you some more time. Heard Ms. P. Kusami, learned counsel for the petitioner, and also heard Ms. P. Das, learned standing counsel, a secondary education department. Ms. P. Das submits that the verification of the documents as furnished by the petitioner in her affidavit in reply
Yes, your lordship.
in the matter is already underway by the respondent authorities, and accordingly she prays that she be granted 2 weeks further time to bring on record the outcome thereof. Prayer accepted. Raised it to list this matter again after 2 weeks on a date to be fixed by. Let's see, ma'am. After 2 weeks, 2 weeks of date that you okay?
Date two.
He'll give it.
Orders item 27.
Madam, date 2.
That is a lot. On the last occasion, compliance report was reacted to.
Mr. N.J. Khatonia has learned counsel appearing for the respondents number 4 and 5 has produced a further communication dated 15/6/2024 received by him from the Joint Secretary to the Government of Assam Department of School Education, wherein again, as noticed in the order dated 31/5/2024, it has been reiterated that the matter is now pending before the Finance SIU Department for approval. Also, it is seen that the file in the matter was endorsed to the Finance SIU Department on 16/5/2024. Also, accordingly, raised it to list this matter again on 26/6/2024, on which date the Mr. Khatonia, the respondents in the education department, in the Department of School Education, shall place on record as to why the said proposal as submitted in the matter by the government is not approved by the Finance SIU Department. Obliged. Yes, Mr.
Contempt matter, Your Lordship. There were earlier orders directed by this court. In the last occasion, they were supposed to place the compliance order, whether they have done the particular
recasting has been done or not, that has to be. Last order.
Now, who is the higher authority other than the government here?
Government itself.
So who is the higher authority about the government here? You have written here the
Right.
compliance of the High Court order. This letter is issued by the government.
Malad.
Now, who is that authority? Governor
No,
or the ministry, government of India? Then
Then.
what is this?
It is wrong statement.
Huh? Why? In a contempt, such casual statements are being made.
The other thing is that.
You get me that clarification immediately at 2 p.m.
Malad.
Who this higher authority is?
Malad, may I pray, Malad? Malad, some time may be.
No, I want that higher authority. Who that higher authority
Other
is?
thing is that.
Or get this person on record. What is she writing? Higher authority, government. Who is the higher authority of the government?
We made a mistake, Malad. Only
She,
thing is-
she has not made a mistake. It's casualness.
Regarding Malad.
These things doesn't look nice.
No.
In compliance of Gauhati High Court order, the main file has been moved to the higher authority for final decision. Who? Chief Minister?
No.
Minister? Who? Just get me a
Only-
clarification.
Malad, some time may be granted. Malad.
2 o'clock.
Last of
You
the-
ask her what this clarification. Now that you have thrown a letter to me, I'll have to give a meaning to that. We'll have it. You have that instruction. Have a call.
Malad, some problem is on my part, Malad. I'm not feeling well, Malad.
You leave. Mr. Chisti, you leave. Go through this communication and I want to ask this lady, whoever this joint secretary is, who is the higher authority she is referring to here? If there is a higher authority than the government in the matter who is considering,
That cannot.
kindly let us know so that we can also, in our next orders, incorporate that. Kindly do that.
Something wrong with there.
Huh?
Something wrong with there.
In a contempt matter,
Yes.
this should not be the manner.
Don't be-
Just throw papers, that will not do. Mr. Bora, you leave. Mr. Bora, you have a copy of this communication? Give it to Mr. We'll have it after some time. Let Mr. Chisti know. So next time when they write a letter, they'll be slightly more careful. That's the only intention.
29.
Thank you, the Lord. The matter relates to, my lord, the filling up of the post of assistant professor in the Silapathar College, my lord, in the Department of Assamese. What happened, my lord, we approached this honorable court earlier occasion, my lord. And this honorable court, right, in its order, my lord,
Okay, that matter.
that matter, my lord. Also, we will find the direction at page 176.
Where's the interim order?
Interim order, my lord, will find that this case, my lord. At 3780. And the order also will find at page 23 of the I.
Now, was this appointment effected of the respondent number 4?
No, my lord.
Has the director cleared the file? Mr. Pine?
Yes, Malad, it is already, Malad, sent to the higher authority.
No.
The
I want to know whether the director has.
Taken a decision.
Huh.
That is, Malad, your lecture impugned, that is impugned.
In the writ petition, that is impugned.
Yes.
Yes, sir, that is at page 177. Of writ petition. By this order, the recommendation made by the selection committee in favor of respondent number 4 was found justified.
Okay. So 2023, the approval, the matter was considered and the prayer of the petitioner rejected.
Yes. And my lord, there is a
And
direction from this.
when did you institute this proceeding? 9/8. Why the appointment did not occasion in between?
But Lucy, I cannot, otherwise Lucy, the expiring order was passed by the authority Lucy on
26,
then-
2023.
2023.
And the writ petition was instituted on 9/8/2023.
Okay.
Interim order was passed
14/8,
14/8.
14/8 Lucy.
Now, what happened in the interim?
In between Lucy, some process are going on probably Lucy, that otherwise Lucy, that is part.
The Mr. Payang, the appointment has not taken place.
Not made, Lucy, not made. Okay.
Yes, Mr. Becca, what is your case?
My lord, kindly turn to page 176 for a moment, my lord. This is the direction issued by this honorable court as to how they will proceed. We are directed to file a representation, the second paragraph. On receipt of a representation.
Okay, fine. They have made some consideration. It may not be proper, according to you. But why should we, on that basis,
My lord,
prevent the students from being taught?
he can join, my lord, but subject to outcome of this.
That's only, no, nothing more.
But my lord, a mark allotted to.
We'll go, because the director has taken a call in the matter, whether that is proper or not, we will
Yes,
consider.
This is under consideration.
We'll consider.
But my lord, a manner in which he was. allowed a mark.
I leave everything open. I'm only concerned with the students. Any appointment that would be made again would be subject to the outcome of this court.
Because there is no such interim order hurrying him from.
Meanwhile, no. Meanwhile, if the respondent is not appointed, same shall not be done till the next date fixed without leave of the court.
Yeah, Lord. And my lord, there is no application from their side.
We'll
Second
consider
leave of
this
this
as
honorable court,
as a leave application.
Yes, my lord.
Heard Mr. J. Pang, learned counsel for the applicant. Also heard Mr. R.M. Decca, learned counsel representing the opposite party number 1. And Mr. K. Gogoi, learned standing counsel, Higher Education Department.
He is the beneficiary.
And also Mr. R. Dhor, learned counsel, appearing for the respond number 4. Also, by way of instituting the present application, the college authorities of Silapathar College have prayed for a vacation and a modification of the interim directions passed by this court by order dated 14/8/2023 in WPC number 4605/2023. Also, this court, while they said order dated 14/8/2023, while issuing notice in the matter, had directed that in the event the respond number 4 is not appointed to the post of assistant professor Assamese, Silapathar College, the same shall not be done till the next date fixed without leave of the court. Also, upon hearing the learned counsel for the parties and also on perusal of the materials available on record, this court finds that the court is now required to adjudicate on the reasons as given by the Director of Secondary Higher Education Assam in the speaking order dated 26/2023, which is the subject matter of challenge in the connected writ petition. First of all, the Director of Higher Education Assam had upon examination of the materials placed before him, concluded that the petitioner, even if would now be granted the marks claimed by her, she would be entitled to receive 2 more marks, and however, the difference of marks between the petitioner and between the opposite party number 1 and the opposite party number 4 herein opposite party number 1 oblique petitioner. And the opposite party number 4 hearing would still, the difference would still be 4.39 marks. Full stop. Accordingly, it was concluded that the selection of the opposite party number 4 hearing was found to be justified. Full stop. In view of the above position and without expressing any opinion on the merits of the reasoning as contained in the speaking order dated 26/2023, and finding that the respondent number 4's opposite party number 4's selection was upheld by the director, this court now this court modifies the interim direction passed by the order dated 14/8/2023 in WPC number 4605/2023 to the extent that the respondent authorities would now be required, now be at liberty to appoint the selected candidate, that is the respondent opposite party number 4 hearing, against the post of assistant professor bracketed SMS, Silapathar College, in terms of his selection for the purpose which was upheld by the director of higher education Assam while his speaking order dated 26/2023. Full stop. Saptara. In the event the respondent number 4 is so appointed in terms of the liberty granted by this order, such appointment shall be subject to the result of the connected writ petition, that is WPC number 4605/2023, and this aspect of the matter shall be incorporated by the Director of Higher Education Assam in the appointment order that would now be issued to the respondent number 4. With the above observation, the writ petition stands. The writ petition, the interlocutory application stands disposed of. WPC Plikibo has agreed to by the parties. The present the writ petition be listed for. You have filed your pleadings, no?
No, so we'll file it.
On 23/7/2024. Full stop. The respondents shall, before the next date of listing, bring on record their respective stands by way of filing affidavits. Full stop. An endeavor would be made to dispose of the writ petition on the next date of listing. 23 Kurishuna, 25 Kuridu.
On 26.
25.
20.
Or you want it thereafter?
Yeah,
30th.
Lost.
30th.
Deeply occurred.
Thirty, 31.
Yes.
The writ petition that challenged the review order.
Yes, Mr. Chaudhary, what do you say?
Lordship decided on the question that there are disputed question of tax. That's why it was sent.
That's why I will send it back.
The earlier judgment was not complied with, and thereafter an order has been passed, which we have already challenged. Lordship, that is pending, which is not before this honorable court today. Lordship,
Huh?
Lordship, the earlier order of the.
There is another writ petition filed by you.
Pending 6. That is not today here.
We will have it together, then dispose it of. But madam, this matter cannot be resolved by this court. You will have to go before the.
My only submission is that all the contentions has been decided by the single judgment.
Fine, very good. You go and place it, they get an order.
Again, they have got the same issue, Lordship, and that was.
That is why we have not accepted his pleas. We have only required him to go before the tribunal.
You said there has been several rounds of litigation. He is suffering.
What is that case number? 62?
6262 of 2020.
62
6262.
of 2024. Heard Ms. A. Talukdar, learned counsel for the petitioner, and also heard Mr. Chaudhary, learned counsel, representing you will be representing Mr. Chaudhary here.
Yes. Already we are responding.
Respond number
The repetition respond number 4 also.
no, Abdul Qadir.
Double.
Respondent, respondent number 6. Full stop. Ms. Talukdar submits that writ petition being 6262/2024 involving similar issues filed by the petitioner is pending disposal before this court. Accordingly, registry to list these matters again on 25/6/2024 along with WPC number 6262/2024. On that day, we will take a call. You also kindly make your submissions what can be done.
Yes.
Services have been completed.
No, madam. Services perhaps yet to be completed.
Yes, madam, you are paying for
In item number 32, I appear for respond number 6.
item
and
number
32.
review 87.
Yes, Your Lordship.
You are appearing for
Respond number 6. And in item number 33, I appear for respond number 1. We have to file a Vakalatama, Your Lordship. We'll
Just
file
a
today during the course of the day.
just a- That means Montumedi.
Want to make.
Lepa. 456. Yeah. Whatever. Oh. 27/5 notices were issued.
From here. Oh. We'll wait for some time. madam.
Wait for some.
We'll wait for. some-
32 clicky, would it? Heard Mr. X.K. Das, learned counsel for the petitioner, and also Mr. K. Gogoi, learned standing counsel, higher education department, representing the respond numbers 1 and 2. Full stop. Seen the office note dated 13/6/2024, which indicates that the notices that the steps notices were issued to the respondents number 3, 4, 5, 6, and 7 only on 27/5/2024. Accordingly, await service report. Full stop. Ms. M. Mohanto, N. Mohanto, learned counsel, has submitted that she is under instructions to appear for the respondent number 3 hearing.
Respond number 6.
6 hearing. Full stop. Accordingly, you file your backup number, then we will say 6 hearing. Full stop. Registry to list this matter again after 4 weeks with regard to an updated status report pertaining to the service of notice upon the respondent's number 4, 5, 6, and 7. Right?
3, 4, 5,
Oh, no, sorry. 3, 4,
5,
3, 4, 5, and 7.
7.
Next to the hop, 32, 33. Heard Mr. H.K. Das, so and so, learned counsel for the review petitioner. Also heard Mr. K. Gogoi, learned standing counsel, higher education department, appearing for the respondents number
1.
2 and 3. Also,
Respondent number one. In second.
is respondent number 1 here.
Reviewing.
1 is review petitioner.
Yes, oh, my friend, yes, I'm sorry,
You are 2 and 3.
yes,
I also made a mistake in the last order.
yes.
একেটা কথা, steps have been taken for service of notice upon the respondents number 1, 4, 5 and 6. ঠিক আছে? একে থাকিব। আৰু list after 4 weeks along with review petition number 87 of 2024. Registered to submit an updated status bill last যে দিছিলো তাতে নাম্বার দিব আপুনি 4, 5 and 6. ঠিক আছে?
34, deep your problems.
The lordship, lordship, service is complete in this matter. It may come up for admission. Service is complete in this matter, lordship. There is a lavazima order.
Family pension. Yes, what is the reason why you are not being paid your family pension? What was your husband working as? Headmaster.
Lordship, I'm really sorry. I'm appearing on behalf of the council. It is.
Okay. On a prayer made on behalf of Ms. S.S. Jia, Learned Counsel for the petitioner, registry to list this matter again after 3 weeks on a date to be fixed by the registry.
The lordship could be paid next week. Could the date be fixed immediately?
Okay, family pension, next week. Next week, 24th को दियो. ठीक है सर? 24th को दियो. 24th. Mata.
Supplementary court is orders item 49.
Madam, this matter, madam, pertain to school management committee, madam, wherein, madam, the petitioner was selected as president. But the madam, DO, madam, has shown the respondent number 9 as president of the committee, madam. On the last date, madam, your lordship passed the order for final disposal to the of the petition itself, madam.
Okay. At 2 we will consider. And to move. It was.
But here in this case, madam, the petitioner was selected as a president of the school management committee in a.
Now, what is the reason for the district elementary education officer in going and approving the name of the private respondent as the president?
Madam,
Yes. Who is appearing?
Yes, madam.
You are appearing
Yes, madam.
for the Mofijul Hawk.
Yes, madam.
What is the reason? How was he selected?
Madam, when the resolution was submitted before the DO, madam, there was a dispute. Thereafter, hearing was held in the chamber of the DO for selection of the members.
How?
Because, madam, that meeting was not adopted unanimously. But initial meeting, madam. But thereafter, madam, hearing was conducted between the chamber, madam. Chamber, and 10% was selected, 10 members were selected from the 31 members.
Where is the minutes of that meeting?
I could not annex to that minute.
Then?
Thereafter, my lord, petitioner and petitioner was not claimed the post of the president, my lord. And one Nurul Huda and the respondent number 9 claimed the post of the president, my lord, at the time of hearing. Petitioner supported the Nurul Huda for the post of the president. He was selected as a member, my lord. Thereafter, Nurul Huda and respondent number 9 get the five votes, in support,
Hmm.
So, president was not selected
Hmm.
and one-man committee was adopted.
Hmm.
Thereafter, one Gao Panchayat member and alumni member supported the respondent number 9. Respondent number 9. As a result, respondent number 9 was selected as the president.
Fine,
That
no
is the
problem, no problem. Now, do you dispute this page 12 of the writ petition? Ah.
Against this resolution,
Do you dispute this resolution?
yes, yes.
Where is the dispute?
In my complaint.
So you mean to say this dissolution was never acted upon?
My submission is that,
No, no.
the-
This resolution was given up,
yes,
right?
Madam.
Okay, then
then,
in the chamber something happened.
yes, the complaint was filed by the many guardians,
Okay, now come
not
to,
all, not
now,
only.
now come to page 24. That is your order?
Yes,
Impugned order
yes,
by which you are recommended, right?
yes,
Right?
yes,
You stand by this?
yes.
Come to that order. Come to that order. This is to inform you that as per the resolution passed by the general meeting of so and so, held on 12/12/23, the SMC so and so is approved as follows. Here the approval is of Mofizul Haq. Whereas in 12/12, the recommendation is of Reza.
Yes,
Hussain. So without
Ma-
change of this recommendation, how could the district, the officer approve this?
We have referred the resolution,
Forget what has happened. That is not reflected here. So
since, at the time of hearing,
we are not concerned. There is no material. That is only your oral statement. This we are interfering. Yes. In spite of so many opportunities, you have not been able to place on record. Okay, show me.
General meeting was held on 12/12/2023.
Hmm.
Thereafter, two complaints was received,
Hmm.
and thereafter hearing was conducted on 29/12/2023.
Hmm.
That hearing, petitioner was also present,
Hmm.
Thereafter, petitioner out of 30 numbers, petitioner got six votes and respondent also got 6 votes.
Where is that material?
I have received the instruction.
Because when you are from the district elementary education officer, you come to page 24.
24.
The resolution of the school authorities was never amended. He is approving that only.
Right.
Where is this intermediate things happening?
After the resolution, two complaints.
I got
were
it.
received,
I got it. But where is that in the impugned order? Come to page 24.
12/12/2023.
Then. So 12/12/23, he has approved. He is not there. So what we do is, in view of this dispute, we will set aside everything, require the constitution of a new committee in terms of the provisions of that rules.
Madam.
But Mr.
MA
Huh?
Islam.
MA Islam, Learned Counsel for the petitioner, also heard Miss. You give me your instructions. Miss S. Chutia, Learned Counsel, appearing for the respondents number 1, 2, 5, 6, 5 and 6. Also heard Mr. Any government advocate, Mr. Soikia was here. Mr. P. Soikia, Learned Counsel, appearing for the respondent number 4. SSA. Mr. Bora is here. Bora is, it's okay, Mr. S. Bora, Learned Standing Counsel, SSA, appears for respondent number 3. Anybody for 7, 8?
9.
No. None has entered appearance for respondent number 7 and 8. While Mr. R. Islam, Learned Counsel, appears for the respondent number 9. Also, the grievance raised in the present proceeding pertains to the approval granted by the district level elementary education officer, Dhubri, for constitution of a managing committee, a school management committee of Barbhangi, Berbangi ME Madrasa, with the respondent number 9 as its president. Also, it is the contention of the petitioner that the resolution as approved by the communication dated 22/2024 dated 12/12/2023 of the general meeting, arrived at in the general meeting of the parents, guardians, and local people of Barbangi ME Madrasa had recommended the petitioner herein as the president of the school managing committee. However, without the said resolution being amended and or a fresh resolution being taken in the matter, the district elementary education officer without jurisdiction had proceeded to approve the school management committee wide the communication dated 22/2024 with the respondent number 9 as its president. Also, both the learned counsel for the respondent number 9 as well as Ms. S. Chutia, learned standing counsel, elementary education department, has submitted that after the meeting, after the resolutions adopted in the school meeting of the school authorities, meeting convened by the school authorities on 12/12/2023, there were developments taking place in the matter, and the district elementary education officer, in view of the complaints received, had conducted a hearing on 29/12/2023 in the matter, and thereafter only the impugned order dated 22/2024 was issued. It is contended that subsequent to the resolution adopted by the school authorities on 12/12/2023, the parties had thereafter again conducted a process of selection in the presence of the district elementary education officer, and wherein the respondent number 9 here, wherein the respondent number 9 was selected, nominated as the president of the school managing committee of the said school. However, on perusal of the communication dated 22/2024 by which the district elementary education officer Dhubri had approved had granted his approval to the constitution of the school managing committee of the school in question, the said aspects of the matter are not reflected, and the same is solely based on the minutes as adopted in the general meeting of the parents of the guardians of the school in question held on 12/12/2023. Also, in view of the above and as agreed to by the parties to the proceeding, the present repetition, the impugned order dated 22/2024 stands interfered with. Also, on account of the interference as made with the order dated 22/2024, the school managing committee as constituted in the manner would now become non-functional. Also, the post of president of the school managing committee would now be held by the district elementary education officer Dhubri and or an official nominated by him in this connection. Also, the respondent authorities are further directed to constitute a school managing committee for the said school strictly in accordance with the provisions. Where is that Act 2000? Huh?
Rule 13 of the.
Page.
Page, my lord, page 53, my lord.
Not 53.
Page 53, rule 13, sub-rule 1, my lord, clause, sub-clause B of clause 2.
Which book are you holding?
2011 rule. Assam right of children for free and compulsory disability.
Page?
Page 53. ma'am.
Hmm. 241.
Only in the old book, 255.
241, 240.
Yes, sir.
In terms with the provisions of the Assam Right of Children to Free and Compulsory Education Rules 2011, more particularly Rule 13 thereof. So the said exercise shall be initiated and completed by the District Elementary Education Officer within a period of 2 months from the date of receipt of a certified copy of this order. So accordingly, the writ petition stands disposed of in terms of the above. Also, in view of the orders passed today in WPC number IMA Ligna, so and so 1052/2024, no further order is called for in the present interlocutor resolution.
Time being 6.
Lordship, can this matter be fixed on any other date? Lordship, Mr.
Sorry.
Based on legs on court number.
Can't help it. Before rising, if he can come, fine. We had already told him, we fixed the matter for his. R. Mojumdar so-and-so submits that he may be accommodated for the day and the matter be taken up on any date after a week. Above prayer is not objected, so-and-so accordingly lists this matter for further hearing on 18/6. What happened to him?
Lordship, there is a rule changing matter going.
He is continuously arguing.
Very
Or the petitioners are arguing and he is listening.
No, not Lordship.
Huh? Ask him, if he does not want to do this matter before this court, just come and tell me, I'll adjourn the matter. Ask him. None appears for the petitioner even on second call. Also, in view of the above, the writ petition stands dismissed for non-prosecution.
17 and 18.
Yes, Mr. Bobby.
Maybe.
There is a hearing going on today.
My lord, here, told my lord,
You don't know.
my lord,
You know or you don't know.
my lord, hearing also, my lord, my petition also, my lord, act my lord, some sort of notice he has received, my lord.
Some sort of, what is this some sort of
My lord,
notice
before hearing, before that.
for hearing? So, if there is a hearing into the issues, same issues,
Yes.
why should we detain this writ petition? We'll close it. Directing the authorities, whatever the hearing takes place, outcome, whatever is there, that will hold the field.
My lord.
Finished.
My humble prayer, sir, let it be.
Will not.
Next week,
No, no, how-
If
If I have to adjourn this matter, then you will have to show me how this hearing took place. Where is that
I
liberty
have
given?
no idea, but I have informed by my client that the hearing is taken up.
You should have come up before this court with an application that how can you hear this matter when the court is in session of this thing?
No, I have no idea, my lord. I just.
Yes,
want to
Mr.
know-
Sharma, what is this hearing business?
Nothing remains, my lord, already, my lord, reasonable court relegated the matter, having regard to the dispute.
Is it in terms of the earlier directions passed by this court?
No, my lord, earlier direction.
In the context of this writ petition, it is mentioned here.
Page 155, this honorable court, my lord, clearly said that, my lord.
Amongst you, who is the 97 appointee? You?
I,
You are from 97. Okay.
and many order, my lord, time to time passed, my lord, in my favor, he never challenged all those orders. By a long process, my lord, finally, I am held, my lord, senior.
What more is required? They are going into the issue. Let them go into the issue. Take a call. Why should we break our head here?
my lord. Even other, my lord, matter will automatically impact on
I
other
will
issues.
pay for next week, my lord. What will be outcome if for
Why
losses,
should
then
I-
losses, then
Am I subject to the
I have no
director?
idea. in fact, my
Mr.
lord.
Council, am I subject to the director's conclusion to arrive at my conclusions in the matter?
No, my lord, of course. not,
Then
my lord.
How
I
can
am
you hold
challenging the
this?
order dated 31/2023. My lord, in the context, just I come across my lord, in the context of this petition, the persons are called for. That is the
Naturally,
subject.
because there is a
Well,
dispute.
why it was called for, how it was, I have no idea. Bro.
Malad,
I just come to know that is why my prayer for losses, let it be in the next week so that your losses may take up the matter, my lord.
Matter will be impact of.
How can it be in the infractions? My lord, the order is against me, my lord. The 31/2023 order is against me, my lord.
You are Nazrul Islam.
My lord,
Your writ petition is 6324.
my lord.
Okay. What is your case here?
My case is that the order passed by the director dated 31/2023 is
3123.
that is a page, last page number 86.
Okay.
If you are supposed to
You show me,
no order. has been
Mr.
passed by the
Mr.
director,
Goswami.
It will be remain, my lord.
Mr. Goswami,
My lord,
relax,
my lord.
relax, relax. There is an application here submitted by both of you individually, giving your service particulars. Where is that? Yes, Mr. Bormia, where is that application?
In fact, my lord, in view of this communication, I even not were not able to prepare the matter because that is.
Don't worry, this court was also not in a
That is
position
why
to
my
prepare.
prayer next week, my lord, any date, my lord,
But I have read this brief. So I remember. Just show me that letter. I found it somewhere here. Where is your application, particular submission of your particulars? I think that
Particular sent, my lord, by
page
the.
E3, page 37, my lord, that is the
Page, my lord,
individual information
One
furnished by the
Uh-huh.
reported
where?
page
Page
37,
of your writ petition.
my lord.
Nazrul Hussain is you.
My lord.
And where is the
Next
same
page.
application for of?
Individual information, page E4, 38.
Okay, Mr. Bormia,
my lord.
this is your application. Page for 38. Huh? What more is left to be considered? Tell me.
My lord.
This is your application,
Page, my lord, 37.
38 writ petition. Do you dispute this?
No, my lord, we are,
Do you dispute this?
our date of, my lord,
Joining is
my
2004.
lord, but, my lord, we are saying, my lord, but my background is that, my lord.
Forget your background. A background without any basis is not required. So both of you joined. I'm resolving it 2 minutes. Both of you joined on the same day.
With all respect, my lord,
Without respect, you can't stand here. I'll draw up contempt.
This honorable court, my lord, having regard to the disputed question of fact, my lord, already relegated to the director, my lord. Can director.
You have come back? Have you asked you to come back here?
No, lord, I have.
Then
come.
you have come back to me?
No, my lord.
You have, both of you have
He
come
has
back? Both have come now?
My lord, he has
Both
to-
writ petitions, he has come, whoever has come.
My lord, my lord.
Mujibur Rahman is who? Who is Mujibur Rahman?
Mujibur Rahman, me, my lord.
You have also a writ petition
Yes.
pending? Okay,
No, my lord, this is my reputation, my lord, to enforce the, my lord, the impute order, my lord.
fine, I'm enforcing it. You and he joined on the same day.
This is formal joining, my lord. But my background, my lord, I am allowed to work in the school by the.
When you are in court, you are in formal dress.
Yes, my lord.
Everything is formal here. No
Formal
informality.
the Same date, my lord.
You joined on 29/11/2004.
Same, my lord. Same, my lord.
Now, both of you, the
Same,
question is who would be senior?
same, my lord.
Simple,
Same, my lord.
simple.
Yes, my lord.
Whether you are senior or he is
Yes,
senior.
my lord.
Your contention is I am working from 1997 against leave vacancy. What right do you have?
My lord.
One. Two. Only thing we'll have to now have a tiebreaker. We'll have to have a tiebreaker criterion, right? We'll apply the date of birth. Whoever is,
So date of birth, my lord, this is not applicable in this rule, my lord. This is bench.
how come then your this non-formal
No, no,
appointment is appointed?
My landed friend, my lord, show, my lord, there is a rule, my lord, regarding. date of birth.
I'll apply them. I'll do.
Lordship,
I'll do it.
lordship,
Tell
they
me
have
your
to
date of
show,
birth.
my lord.
Tell me your date of birth.
Date of birth, my lord, not with me right now, my lord.
You don't know. It is 1/10/1974. And his is 1/8/1974.
My lord,
He gets it.
lordship, my lord, there are, my lord.
That's the end of the matter.
The orders, my lord, in this.
The
matter.
director need not break her head.
My lord, they have
We'll
to-
clear the
I'm
matter.
fixing on
Okay,
earlier
clear
to
it.
Supreme Court judgment, my lord. They have to show, my lord, violation of the order, my lord, violation of the rule, my lord.
Supreme Court order.
Yes, my lord.
Mr. Goswami, don't be agitated in every matter.
My lord, sorry, my lord.
Huh?
No.
Now you wanted an adjournment?
No, my lord.
We are adjourning them.
My lord, I have no copy, my lord. Earlier occasion, I also furnished, my lord. Referring Supreme Court judgment, my lord, this is the honorable, my lord, High Court's order, my lord, another Supreme Court order, my lord.
Oh,
Yes.
Tata Cellular. Tata Cellular.
Yes, my lord.
You're relying on Tata Cellular.
Just for,
Anything more?
because, my lord, lordship, kindly, I may be allowed to
Okay.
submit, my lord.
Hut, Mr. A.R. Barvi, a learned counsel for the petitioner in WPC number 4889-323, and Mr. U.K. Goswami, learned counsel for the petitioner in WPC number 632423. Except Madana. Also heard Mr. U. Sharma, learned standing counsel, secondary education department for the state respondents. The issue arising in the present proceedings pertains to the intersect seniority between the
My lord,
petitioners
my lord,
in both the said writ petition, and accordingly basing thereon the question as to who amongst them would be now entitled to have their services provincialized under the Act of 2017. Full stop. While the writ petitioner in WPC number 4889-2023 contends that he, although was formally appointed in the school on 29/11/2024, he was working in the school against leave vacancies since 1997. While the writ petitioner in WPC number 6324-2023 would contend that he also being appointed by the managing committee on 29/11/2004, like the petitioner in WPC number 4889-2023, comma, and there being no order formally appointing the petitioner in WPC number 4889-2023 from a date prior to 29/11/2024, comma, the services rendered by the petitioner in WPC number so and so 4889-2023 prior to 29/11/2024 would not be reckonable. Also, given the above factual position as coming to the forefront in the writ petitions involved, comma, this question is the court is now required to decide as to amongst them who would be senior. Full stop. Both the petitioners having in the writ petitions having joined on the same date, 29/11/2004, comma, the only manner in which the synthesis seniority can be decided is by reckoning their respective dates of birth. Full stop. The date of birth of the petitioner in WPC number 4889-2023 is 1/10/1974, while the date of birth of the petitioner in 6324-2023 is 1/8/1974. Accordingly, it is seen that basing on the date of birth, it is the petitioner in WPC number 6324/2023 who would rank senior. However, the application of this criteria is disputed to by the Learned Counsel for the petitioner in WPC number 4889/2023. Accordingly, the present writ petition stands adjourned for 6 weeks. Full stop. Disputed by so and so. It is stated in the bar today that the Director of Secondary Education Assam is holding a hearing of the petitioners in the above noted writ petition to ascertain the authenticity of the claims in the present writ petition. Also, accordingly, the parties had at the outset prayed that the matters be not taken up today and be listed on or listed after they said after the Director Secondary Education passes orders basing on the outcome of the hearing being conducted today. Also, in the above view of the matter, while the hearing as conducted by the Director is not interfered with, the Director is required while passing the final orders to take note of the observations made in this order herein above, and thereafter only to pass appropriate orders in the matter. Also, registry to list these matters again after 4 weeks on a date to be fixed.
There are so many orders passed in my favor.
I have passed an order, Mr. Burmia. If you anyway agree, go before the.
Because he has not, my lord.
These are not issues to be kept pending like this. Simple.
Director's order does not.
You show me from 97. Mr. Burmia, don't allow me to make that order worse for you. I can go ahead. Do you know how you were provincialized? Your date of birth, your date of joining was taken. Your date of joining was taken not as 29. It was taken as 21 or something, and then you were held to be senior. I can even go into that. I'm not gone into that. I can go into that fact also, mister. I don't want to go into that. Not required. But if you insist, I'll go into that. Do you want to see how you were made senior? You want to see? I'll show you. Come to page 67. District Scrutiny Committee. Know where your 97 expect was taken. Come to District Scrutiny Committee.
67
of WPC 6324.
Yes.
67 you have got?
Yes.
See the date. 29/11/2004 as per the headmaster. Right?
Yes, sir.
As per the director, I don't know from where the director has given this date. 22/11/2004.
One date is there.
22/11 that is the date when your the managing committee had adopted a resolution to appoint you.
And may not have page 73.
So don't take me deeper into it. It is bad for you. I've left it here. You have prayed. I have left it here. Mr. Goswami was very much insisting that it should be taken up on some other date. I've done. But what facts comes to my notice, I think I should record. So I have recorded.
28-year lordship, that was an inadvertent mistake, lordship. And lordship just, and John Secretary told me that within 10 days, lordship, that speaking order will be issued. 10 days time may kindly be given, lord.
On the prayer of Mr. SMT Sisti, then I have not seen this.
Yes, sir.
SMT Sisti who submits, who undertakes.
High Court's order specific how what to be done. That is specified.
That is in anything they do will be in terms of this order.
Yes.
Mr. SMT Sisti, Learned Counsel, appearing for the respondents, has submitted that the matter be taken up after 10 days, by which time the compliance order in terms of the directions passed by this court would be produced before this court. Also, accordingly, raise this matter again on we'll have it on 28th,
Yes,
last date, but I want that order on that.
yes.
And ask your officers.
Yes, I have,
not-
I have already, I have it.
I don't know whether the can be taken up on that. Last day of the court.
Just make a mention.
I'll put it, no,
Just make a
This
mention.
order
Ask your
can be not
junior,
taken.
your
Yeah, yeah. I'll do.
junior, ask her to make a mention at 10:30. We will have it at 2.
Much.
obliged.
P6.
Which looks in Mozambique is still in court number 5 in the special division.
No, I've asked him.
No, he is in court number 5 lawsuit. Division bench is going on, special division bench.
He's arguing.
No lawsuit, he is the nothing,
Hearing.
he is nothing lawsuit. So
His juniors can't make those notes these
No.
days.
he is representing the education department.
Whatever it is. Oh. Yes, what did he say? In Lex. Okay. Or he did not.
All of them.
List again on Thursday. Thursday. Get it. By sleep, what had you work? I'm not at 20 work. Yeah, I'm hearing. Mr. Sharma, if you are waiting for that Ankit Jori, sorry, I'm not in a position to do it today. Health not permitting.
Heading item 35 to 38.
That issue involved in this case, my lord, it is simple. The petitioners are the originally they were the.
Yes, you are paying for?
Finance.
Who is appearing for the elementary? Yes, what is your stand?
They have filed their affidavit, my lord. Their affidavit says that they are standing, they have given the, what they are stating, my lord, they have given the charge allowance. Charge allowance is not the increment, my lord, on the, it is given to everybody who is not promoted. Even someone is holding the charge, in charge of a post headmaster, my lord, of LP, UP, those teachers are also given the charge allowance. This is not the promotional benefit. Promotional benefit has to be within the framework of the basic salary, my lord. Basic salary includes the, it's a grant of additional increment. Here in the instant case, what
You all are
we
any
are
school
science graduate
headmasters.
teacher. We are science graduate teachers initially, and our salary is same as scale of pay with regard to headmaster
Graduate.
and the other graduate teachers now. What happened, my lord, at the time of promotion, when there is similar scale of pay from the feeder cadre and the upper
You are in the ME school.
ME,
The schools were amalgamated.
not amalgamated.
You're still in the ME school.
ME.
Your case is that I being a science graduate teacher, are you getting the salary equivalent to that of a graduate teacher in the high school?
Yes, yes, we are getting the graduate teacher of the high school as well as the, my lord, the headmaster of the upper primary school. Our case is that you are giving us promotion without any benefit.
Promotion to what?
Promotion to the post of headmaster of the upper primary school.
Okay, that means you mean to say that on being promoted to the post of headmaster,
Yes.
you are drawing the same scale, maybe you are given one
One
increment.
increment, it is admitted, my lord, position. And what happened, my lord, on the other hand, you are depriving us from the getting the MSCPS benefit. In a service life, my lord, 30 years of service life, 3 additional increment is, and everybody is entitled. And on the name of promotion, yes, you have been promoted, you are not entitled for MSCPS benefit. 1 increment goes. And in the promotion status, my lord,
What is the stand of the government here?
government, they have not addressed this particular
No,
point.
finance.
Finance, my lord, they
Yes.
have filed their affidavit, they have stated, my lord, they are, we are getting the allowance, charge allowance, and as such, we are
How
not.
can it be a charge allowance if you are ordinarily
Charge allowance
promoted?
is something different, it's not the buying chalks and dusters for the school, my lord. This cannot be accrued as a promotional benefit. This is the main issue, my lord. And their stand is that they have not
And then ROP itself, my lord, says, my lord, ROP 2017 also says clause 11. I'm giving you.
Where are the
FR 22C also and the ROP 11, my lord.
FR 22C?
Yes.
That is already gone.
And my lord, in the ROP, my lord, I have given, my lord,
That is already gone. Why are you reiterating that?
11A, my lord, 1A. One increment equal to 3% term of the sum of.
Those are your clients outside waiting,
No, my lord.
not your clients. Yes, Mr. Gogoi, that same very issue, I suppose, which is there before the.
No, my lord, here, my lord, I have also checked it. There, my lord, actual, my lord, science graduate teacher.
So if they are science graduate teachers, the post of science graduate teacher pay
8,600.
and the headmaster is same.
Yes, that is the position.
So once they are promoted,
Yes,
they lose MACP.
no. MSCP says that, my lord, one promotion by 10 years.
That's
Again,
what I'm
20,
saying.
10,
20
30.
years or 30 years, that promotion, one MACP will go.
Of course, yes. Sir.
One MACP will go. Nowadays, for promotion, if you get a MACP, what do you get? Basically, the higher grade pay.
Yes.
That's all. If the higher grade pay is to be converted into the pay band, what would be the effect? What would be the percentage?
It is 3%. or
3%. No. Corresponding to that grade pay, if we see,
Loss.
why don't you give them one extra increment? That will solve the matter.
No, increment, extra increment, they are getting other ways.
No. FR 22-1A, they get one below, one up.
Lots.
In addition to that, give them one more. Finish. That's the end of the matter.
If that, if the loss is
No. You get me.
No, that's why I can have the instruction.
You get me. You get that instruction. Mr. B. Gogoi, Lalit. Counsel appearing for the finance department shall, on the next day, place before this court the manner in which the pay of the petitioners herein were fixed on their promotion to the post of headmaster, inasmuch as it is stated that the pay band and the grade pay,
and the pay band.
pay band and the grade pay for both the posts are one and the same.
Yes.
Also, the promotion to the post of headmaster being requiring the incumbent in the post to discharge higher responsibility. So the provisions of FR 22-1A1, I suppose, will not put it. Responsibility come out, so and so. It is now required to be examined as to how the grievance of the petitioners in the matter can be redressed. So the said information be placed before this court by Mr. Gogoi on the next date of listing. We'll have it before vacations.
Yes, sir. Got it.
Let it be on 21st. Will it be difficult? Friday?
No, next week.
Monday?
Yes.
24th.
Offline.
This is the only issue required.
Yes.
On 25th, my lord.
25th.
I will get
25th. Take it.
My lord, I have got the judgment of the effect court. It says that, my lord, just because somebody is promoted, he is not, my lord, entitled for any higher pay. It need not
No.
be.
Here the promotion is
FR
to a higher post.
Yes.
It is a different thing. Promotion can be to the same cadre of post. That there is no dispute. But the manner in which you have structured your
Lots of.
service, this post also has administrative activities. It's a higher responsibility.
Lots of.
If that be so, others would get a promotional benefit. Say any other teacher, a graduate, not a science graduate teacher in the ME school, when he is promoted, he gets a good benefit.
Yes.
Yes.
Right? Then one MACP going will not make any difference. It will be because he is the other one of it. For him, one MACP will go like that.
Yes. That is the thing.
That we cannot permit.
Offline.
39.
You examine. Maybe there is some justification somewhere. Just place that before me. Yes, Mr. Bachchaji.
My lord, this is a case of non-payment of salary upon provincialization. Pursuant to the order of this honorable court, the service of the petitioner is provincialized. Lordship may see the order as case 19. This is the order. Respondent number 7 is the petitioner.
Yes, why, madam?
Lordship, the area proposal, Lordship, it was submitted by the IS Kamrup, Your Lordship, Metro on 2nd of April 2024, Your Lordship. So, Lordship, I had inquired, Lordship, it was submitted to the Director of Secondary Education, Your Lordship. It is under process, Your Lordship.
From when did you receive your salaries, Mr.
Lordship, from 1/3/2016, Your Lordship. He had been receiving the salary, Your Lordship.
Now tell me. This is a provincialization exercise.
Lordship.
You don't provincialize a service of a person until the proposal is cleared by the finance department. Huh? Why the salary was not paid? Because this money had come to you along with this creation and sanction of the post. Why was page 22?
Because through a corrigendum, Your Lordship, her provincialization was given effect from 2013, Your Lordship. So from 2013.
It was the admitted position.
From 2013 to
22, in view of the above, you are requested to take necessary action towards the release of the salary of the current year 67 to the.
No. Before that, that is what I am saying. Come to page 22 itself. First paragraph, last line. Accordingly, Finance SIU Department's appraisal number so and so is issued to facilitate royal of first pay of the new appointees. You get my point, madam? So the money, the approval, everything was with you. Why did you? And there is nothing here in your. Who is this respondent? He's a headmaster. He is nothing. So, madam,
Lordship.
when?
Lordship, after 2 weeks, Your
No,
Lordship.
no. You have retired. You have serving. Serving. We'll have it next week. You get your instructions.
Lordship.
Miss D. Mushahari, learned. Standing Counsel, Secondary Education Department shall place on record the record instructions, record as to the reason as to why the salary of the petitioner was not released with effect from 1/1/2013 to 28/2016. Also, while receiving the said instruction, Ms. Mushahari shall also apprise the respondents about the communication dated 14/7/2016 issued by the Finance SIU Department in respect of the petitioner, wherein the approval was already granted to the authorities in the Education Department as well as the Treasury Officer, New Guwahati Treasury, for drawal of the salaries of the petitioner herein with effect from 1/1/2013.
Can a direction to be issued to, within a pay the amount within a fixed period of time, relatively 6 months, 3 months, 2 months, whatever may be.
Oh, we are trying to get it done immediately. Why 3 months, 4 months? Ms. Bushari, you place this instructions on Monday next.
Lordship, Monday.
List on Monday.
Obliged, Lord.
6 months, 7 months, my work will go up because you will come back with a contempt.
Lordship.
I don't want that situation.
41.
Yes, Mr. Bulba.
41 and 44. What are the same? 41, I think 41 and 44.
Hmm.
The board has said.
Oh,
in fact,
44
this-
today, okay?
In fact, this similar matter already tagged to with this case, this speaking unfortunately that are not coming. Possibility of court order is there. And therefore, my prayer is that the all matters will come together because on that case, the government have filed affidavit and we have also giving the reply on both there. Therefore, my prayer is that they all together. This is only case of retirement, non-receive of retirement benefit for the person and who has joining after.
You are all regular people,
Yes.
regular
30
appointees,
years
no
of
doubt,
service,
no
30
dispute.
years.
No dispute with regard to your service.
Our service is also confirmed.
Which district?
On petition.
Hemaji?
Yes, and therefore, all
Oho.
matters should come together. Then
Oho.
we'll play because
No, no,
a theory in the during this period, key litigation has been.
Yes, what is your ground for not releasing to them their salary?
As far we have filed our affidavit, my lord.
Hmm.
As far our instruction one affidavit,
Hmm.
they are, my lord, irregular fixer, my lord.
Irregular.
My lord, they are appointed against non-existing force, my lord.
Services terminated.
My lord.
Services terminated or not terminated?
It was terminated, thereafter the court intervenes.
Show
That
me.
is stated.
Show me that.
113, my lord, page 113, annexure 2, our affidavit. my lord.
The judgment of lordship fine. Is page 35. Judgment is given, the authority board is in the procedural page 38.
Petitioners are here.
Which petitioner name was? The petition number 1 is lordship fine in serial number 36. Petition number 2 is lordship fine, the serial number 17. And petition number 3 will lordship fine in page 46, serial number 47, and 4 is 54.
And thereafter, what did the authorities do?
And their file review was also dismissed.
Then your services were
And
confirmed.
thereafter they are sending to the training, and they will complete training and they get the regular pay scale. Yet on 2007, suddenly without reason their salary has been stopped. They opposed this honorable court. The honorable court by judgment on WPC 1/2/1998 allowed the petitioner and directed it to pay the salary, and that judgment would lordship fine in page 46. Page 46.
GPF accounts were also opened.
GPF already we received. GPF amount already we received. After the filing of this petition, the GPF amount has been released. On that order, the court frequently stated that the earlier the order was body is attend finality.
Mr. Purva, what is this para 9, page 104 of the
100?
affidavit? Okay.
Yes. What is happened this government?
Was any notice issued to you
No,
after this?
no,
No.
that is my guess.
Where is your reply to this?
In our
Para
reply.
9?
paragraph 6 of my reply, page 123. After the verification report is submitted by committee, considered authority, it has been suggested to issue so-called notice to the incumbent so that the incumbent contract can defend the case. Admittedly, that one order had not furnished
Yes,
the
Mr.
report of the committee.
Talukdar,
My lord,
what is there?
my lord.
What is there left?
And no opportunity to place the paper. And
Huh?
their affidavit also said that they have not issued the notice. That will find lordship fine.
Okay. Heard Mr. P.P. Borwal on 41 and 44, huh? Heard Mr. P.P. Borwal on counsel for the petitioner and also Mr. S.B. Talukdar, learned counsel appearing for the elementary education department and Mr. And Mr. R. Bhuttajari for the learned counsel appearing for the finance department and Mr. That for the respond number 6. 6 and 7. No, 7. 7. Is present there, WPC 635. Also, it is contended at the bar that the pleadings in the matter are complete and accordingly the petition can be taken up for final consideration. Also, accordingly, registry is directed to list this matter again. When? Before vacations? Tuesday next, 25th? 25th? Not very high. No, don't seem to be very happy. After the vacations. Now he is happy.
That other cases will be come together. That affidavit we have to rely in that particular case.
Okay. Also, the registry to list this matter after the ensuing vacations along with WPC number 4012-23 and 4013-2023. Also, 44 में लिखिएगा list this matter again after 4 weeks along with WPC number 635-2023.
Because on that case, they admitted that they have not issued the notice.
That's the end of the matter. None has appeared for the petition on call. For the interest of justice, registry to list this matters again after.
It's on Tuesday next.
Tuesday won't be
The
possible.
recruitment in the university has been stopped. The recruitment in the university has been stopped.
Immediately after vacations, immediately on reopening. That is on after the ensuing vacations on 16/7/2024. You are here on 16th? 16th you are here?
Yes, I'm.
16/7.
23rd.
25/7.
23rd.
23rd, 23/7/2024. Also, Mr. S. Kal, learned counsel appearing for the respondent university, Mr. K. Gugoi, learned standing counsel, higher education department and CGC, sorry, CGC and Ms. P. Agarwal, learned counsel appearing for the UGC are present, huh?
Dr. Pooja Agarwal.
Dr. Pooja.
Dr. Pooja Agarwal.
Sorry, sorry.
Party.
Delivery of order item 1 and 2.
बाकी सब ठीक नहीं है। ये वो डेट दी